I have been on this bench long enough to know that contempt usually arrives before the sentence does. It enters in the walk, in the posture, in the way a person drops into a chair, as if the room should be grateful he bothered to appear. That was what walked into my courtroom the morning Chase Thornton III stood before me. He was 24 years old, son of Senator Robert Thornton, heir to enough money to have confused comfort with character for most of his life. The matter before me looked like a small civil claim. Marcus Webb, 19 years old, college student and valet parking attendant, suing Chase for $8,500 after Chase destroyed his 2008 Honda Civic outside a Manhattan restaurant. Paper never tells the whole truth. It does not show you the look in a young man's eyes when the car carrying him to school, work, and home to his diabetic little sister becomes twisted metal because someone richer wanted a laugh. Marcus sat at the plaintiff's table holding a worn folder tight against his chest. His mother cleaned hospital rooms and worked a grocery register. His father drove rideshare, worked construction, and picked up security shifts. Marcus worked nights as a valet to stay in college. Civil engineering, big dreams, little margin. That Honda was not just transportation. It was how he kept life from falling apart. Then Chase walked in late, wearing designer sneakers worth more than many people's rent, an expensive jacket, and a smile that told me he had mistaken every prior rescue for proof of his own brilliance. He dropped into the defendant's seat, phone in hand, and looked bored. I began simply, "Mr. Thornton, thank you for joining us." He said, "Can we make this quick? I have a yacht party at 4. Marcus presented his evidence. Photos of the destroyed Honda, police report, witness statements, screenshots from Chase's Instagram post. That post mattered. It showed Marcus's wrecked car with the caption, "Whoops, ran into some peasant's rust bucket." I asked Chase whether he denied damaging the car. He smiled and said, "His piece of junk was in my way." I asked whether he had exchanged insurance information. He said, "Insurance is for poor people." The room reacted as it should have, not loudly, with stillness. I asked whether he understood he was under oath. He laughed. "Under oath? Lady, this isn't real court. You're a TV judge playing pretend." Then he said the line that froze every person in that courtroom. "My father makes more in a week than you've made in your entire pathetic career. You can't touch me." I reached for the sealed manila envelope on my desk. His smirk faltered. Inside were federal documents, wire fraud, tax evasion, witness tampering, interstate commerce violations. Marcus Webb's civil claim had opened onto something much larger. I had spent the previous 72 hours coordinating with federal investigators because Chase Thornton had a habit of telling the truth about himself. I looked at him and said, "Mr. Thornton, you are correct that this is arbitration, but threatening and showing contempt toward a federal judicial officer assigned to this proceeding is not entertainment. It is evidence." His face changed, first confusion, then disbelief, then fear. I told him what was in the envelope. $4.2 million in wire fraud tied to a cryptocurrency scheme, $3.8 million in unpaid federal taxes, witness tampering across prior matters, interstate movement of contraband luxury goods, and video of him bragging at a private party that prosecutors and judges could all be bought because his father owned half of them. He stood so fast, he nearly overturned his chair. "You can't," I cut him off. "Your father is watching this from Washington right now." He reached for his phone. I told him to put it down. He did not. The United States Marshal posing as my bailiff took one step forward. 4 agents rose from the audience. The moment was not dramatic because anyone shouted. It was dramatic because everyone understood at once what had happened. The untouchable man had finally been touched. The Marshal announced the arrest. Chase Thornton III, under arrest for federal wire fraud, tax evasion, witness tampering, and contemptuous interference with a federal judicial proceeding. The handcuffs clicked. He yelled the linemen like him always reach for when reality finally arrives. "Do you know who my father is?" "Yes," I said. "And by tomorrow, he'll be known as the father of a convicted felon." The public later treated the arrest as spectacular justice. Fine. But what mattered more was the record. Chase could no longer slip into one more private settlement, one more quiet favor, one more erased file. Wealth survives on amnesia. Records deny it. Marcus's life changed too. Strangers raised money to replace his car. Scholarships came. So did job offers. He later started a foundation helping workers and students document abuse by wealthy clients and employers. What stayed with me after the cameras were gone was not Chase's face when the cuffs went on. It was Marcus walking out with that folder still held against his chest, only now not like a shield, like proof that truth can occasionally survive contact with money. That is what a courtroom is actually for, not for flattery, not for influence, not for the private reassurance of powerful families who think procedure is another service industry. A courtroom is where facts are supposed to grow heavier than wealth, where a 19-year-old valet stands as full-sized in the record as a senator's son. If you want the simplest version of the story, here it is. A poor young man worked hard, got hurt, and refused to disappear. A rich young man hurt people for entertainment and believed money had made him immune. One brought documents, the other brought contempt. The law decided, for once, to recognize the difference. That is not revenge. That is justice.